Hi, good afternoon, everyone. Thank you, ST Property and SAEA, for having me here. Thanks, Nicholas. I think he has painted a positive picture of buying property in Singapore, at least for me. Now I feel very much relieved. But now on a gloomier note, okay, something that I'm going to share with you may not excite you that much, but nonetheless important. Just a brief description of myself. I'm a practicing lawyer. I have my own law firm with 11 lawyers. Primarily, we do litigation. That means black and white, we go to court day in, day out, and we fight. And one of the, well, I wouldn't say popular, one of my clientele is yourself, real estate salesperson. For some reason, I have many friends in your profession. I have represented many of you in court, fortunately or unfortunately, sometimes suing people, sometimes getting sued. I've also, as we speak, have ongoing CEA proceedings. So I'm defending some of you at the CEA, and I can assure you it is not pleasant. It can be very stressful. So this topic, usually I do it in 3 hours, but I'm going to shorten it, actually no choice, to 45 minutes. So please bear with me. I'm just going to highlight to you some of these common legal problems that hopefully you will not get involved in, but if you do, how to avoid them, okay? All right. The scope of my session will be to basically share with you, just give you a brief introduction, why it is important to know this. Especially, I understand that 75% of you are in the real estate industry. You are salesperson. So I think it is important for you to know. Given that the market is not exactly rosy right now, I think the last thing you would want is to get into trouble. All right? And what are some of these common legal problems? How to avoid them or resolve these problems? And what are the different types of dispute resolution method? As I mentioned earlier, I'm a litigator. That means I go to court. I do a bit of conveyancing, but most of my work is court work. And I would share with you that actually going to court, contrary to what most people know, is always, I would say, the last resort. We do have other mechanisms like negotiation, mediation, arbitration, and litigation. Litigation means go to court. But you should always try to attempt other form of dispute resolution mechanism before you actually think of going to court. But sometimes it is not your choice. Because sometimes the house owner or the landlord sue you or the tenant sue you, then it is really not your decision, right? So introduction. Why it is important to understand these common legal pitfalls. As I've said it many times in my class, it is important for you because nowadays the consumers are savvy, all right? They know how to get legal advice, and now we have the CEA. They also know where to lodge the complaint also. So these are information readily available. And that means that it is, I would say, for want of a better word, harder to practice, okay, plus this kind of market. So it is important that you are equipped with information like this so you know how to navigate or you know how to avoid potential problems. If not, believe me or not, these problems will actually affect your livelihood. And I say this with certain amount of conviction because, as I said, I have represented quite a number of you in court. And for me, it is bread and butter because every day I go to court, right? So, but for some of these clients of mine, if they get involved in a lawsuit or they get involved in a complaint, their life more or less stands still. You know, the cases can last a couple of months to years. And during this period of time, it can be very stressful and troubling. So it will affect your livelihood. It will affect your life. So that's why it is important for you to know so that next time when you're on the ground, when you're doing all the selling and marketing, you will know how to avoid these problems. Like what Nicholas said earlier, it's entirely up to you. You are given certain facts. It's how you present it to them, to the clients, right? So if you present it wrongly, then you may actually land yourself in trouble. So it is important for you to know, all right? What implications are there if faced with this problem? Civil, disciplinary, or even criminal. If you get a complaint to CEA, you're looking at disciplinary proceedings, okay? Your license may get suspended if you're convicted, of course, or revoked, get a fine up to 75,000, reprimand, or even having certain conditions attached to your practice. These are some of the things that CEA can do. if the complaints are found to be true. But in addition to this, you may also get sued in a civil court. And when you get sued in a civil court, you are looking at damages, money, all right, or specific performance, have to deliver certain things. But most of the time, you will not be the person directly involved. Most of the time, you're between the landlord and tenant or between the vendor and the buyer, and you are normally roped in as a third party because you are the agent. And agent's activities bind the principal unless you are doing something so beyond your scope, all right? Or even criminal. I'm not sure if you have come across, there are certain agents who actually ran away with their client's money. If that happened, we are looking at CBT, all right? So these are the three potential things that you may be looking at. First one, misrep. Okay, this is a classic. In my years of practice, about 15 years now, I've seen many of these cases happening. This is quite pertinent for a real estate salesperson because I think probably the nature of their work involves selling and marketing. What is misrepresentation? Basically, it's an actionable false statement, sorry. It is a false statement of existing or past fact made by some party before at the time of the contract. And this representation induced somebody to enter into the contract. To make it simple, basically you have said something. Okay? You have said something which turned out to be untrue. And this statement was relied upon by somebody to enter into the contract. In your context, what are these contracts? OTP, right? TA, or SMP. These are some of the contracts that you would help your client to enter into hopefully frequently. Okay? So basically, misrepresentation is that you have said something to a potential buyer or to a buyer's agent or to a tenant's agent, for instance, that turned out to be untrue, okay, inaccurate. And these statements, this representation, was then relied upon by the buyer or the tenant into entering into the contract, whether it's to buy the property, exercise the option, or sign the TA. And then subsequently, they find out that whatever you said is not true. Just to give you an example, maybe using Nicholas' example, the Jurong Lake District, so on and so forth, right? And then tomorrow you went out there, you go out there and you start selling. Say Jurong Lake District is such a beautiful place. If you buy a property there, you'll make millions of dollars. Within a year, the property will go up by 30%, 50%. I do not know where you get the facts from, but you just whack, you know, because you're in the business of sale. And then there's a buyer relying on what you say, buy the property. Turned out that 1 year later, the property prices did not go up by 30%, in fact, quite flat. And of course, that being the case, they will be unhappy. And being unhappy, they will look for somebody, right? So of course, you will say, no, I didn't say that, right? Nothing in black and white. But nothing in black and white doesn't mean you did not say. The only question is to prove, correct? So it's always verbal. Verbal doesn't mean no contract. Contract can still be formed even though it is verbal. Please take note of that. All right? So just to share with you a case study that illustrates this point clearly, there was a real estate agent sued by the buyer after helping an owner to market an office space. In the newspaper advertisement, it was stated that the size of the office was 1,450 square feet. This got the buyer and the buyer agents interested. And after the buyer's contractor made measurements, they realized that it was only 1,300. The real estate agent's client instruction was that he only estimated the size based on the office unit upstairs. So he assumed downstairs should be the same, right? Fortunately, in the end, this case was settled and they didn't go to trial. This is a real case that I handled. It's a veteran agent of 18 years experience, never had any complaint, was never sued. He came to me, he was crying. Okay, he said, I'm not sure why this had happened to me. So by the time he came to me, he already received the summons. Okay, who sued him? Basically, his own client. Okay, he was acting for the vendor. Right? He represented the vendor as a vendor's agent. He advertised in the Straits Times, and he said that it was 1,450 square feet. He even had the advertisement he showed me. So the buyer was represented, the buyer's agent, a fairly new agent. They met up, they viewed the office, and the buyer liked it. And the funny thing is that during the viewing, right, the vendor's agent, my client actually showed passed a piece of title search to the buyer's agent. Okay, but somehow nobody actually bothered to read. So the title search was changed, hence I'll take a copy of this. So the buyer's agent actually took, they say, you like the unit? Like, basically they buy it, exercise the option, the contractor came down, measured, it was 1,300. So it's 150 square feet multiplied by $300 per square foot. So that was the amount of damages that they were claiming, or that they're going to claim against the seller. Of course, the seller would say that, hey, I was represented by my agent. I was not there doing the selling, you know. But of course, as far as the buyer is concerned, it doesn't matter. The seller and the seller agent, they are one and the same. So of course, the seller not happy. The seller also roped in my client. And the seller basically said that whatever that I have to pay, I'm going to get indemnity from the agent. So of course, he was worried. He came to me. I asked him, how could this have happened? You know, the size is all stated there, right? In your title search, which you printed. He said, yeah, I did, but I didn't check. I said, then why did you print? I said, I don't know. Practice just dictate that I should print it out, and I just hand it over to the buyer's agent. I'm not representing the buyer. Why should I owe the buyer a duty of care? So he was complaining, said that's not fair, life is unfair, you know. He said basically it should be the buyer's agent's fault. The buyer's agent had a copy of the title search, and she did not advise the buyer. So why should it be me now? Why should they sue me? Right? So all this, you know, he was crying, he was complaining. So at the end, he did not check the title search. Right? But the contractor did the measurement, it turned out to be 1,300, and that's a fact. So he got sued because of that. So basically, what actually happened is that, of course, we went forward with the trial. No, we didn't go forward. We went forward with the proceedings. Parties were able to resolve that dispute, okay, by sharing the damages, 1/3 each, between the owner, the buyer, and the seller's agent. All right. So when I asked him, why did you advertise 1,450 when you are not sure? He said because he marketed a unit upstairs before. It was 1,450, so I naturally assumed. We got different sizes in the same building. I said, obviously there are different sizes in the same building. But somehow he assumed that they are the same. So what could have prevented this unfortunate incident? Maybe it's in the way he advertised. If he had put a word estimated, approximate, subject to survey, things could have been different. Simple things like this. What words you use in your advertisement could actually mean a lot. But he has stated it as a fact. 1,450, no more, no less. And this size was actually relied upon by the buyer when they exercised the option. So it became a misrepresentation. So be very careful, all right? So what are the other examples of common misrepresentations? Size and tenure of property, okay? 99, 999, fee simple, freehold, 60, 30 years. All this information can be found in the title search. It doesn't cost much, I think $5.16 or 15 cents thereabout, okay? Number 2, eligibility to buy for foreigners. Foreigners are not allowed to buy non-strata title, residential, without approval from a land dealings approval unit. Confusion relating to residential or commercial property, foreigners are allowed to buy commercial landed, okay? Mixed-use property, with the exception of Sentosa Code, which is gazetted. So, to cut the long story short, foreigners are not allowed to buy landed properties in Singapore, okay, with the exception of cluster housing, okay, townhouses. These are considered strata-titled. Basically, what we are referring to is your semi-Ds, your terrace houses, without the approval of the land dealings approval unit. So, ladies and gentlemen, when you have a foreign client coming to you, say, I want to buy a semi-D in East Coast Road, don't turn them away straight out. You can always try to apply or help your client to apply for LDAU approval. All right? There are some criteria that the LDAU will look into. They do not publish these criteria. But it really got to do with the profile of your client and whether they're buying this property first time for own use and their contribution to the economy. If this is their second property or investment property, a good chance that this application will be turned down. Okay, so do not turn away the client straight away, I would say, but always say that, okay, if you're interested, we have to apply for LDAU approval. And in your option, I'm not sure what option you use because many of you come from different agencies. Go back, take a look at your OTP, make sure there's a LDAU clause inside, okay, which is fairly standard to say that in the event the purchaser cannot buy this property or fail to get the LDAU approval, then the whole transaction is void. The buyer can get back his 1 or 4% or 5% without interest. Make sure you have this clause to cover yourself, right, so that you will be assured. Because sometimes you may not check or you do not check the identity of your prospective buyer. Let me share with you a case study. Another close friend of mine is a real estate agent. Years ago, he called me up in the middle of the night, say, problem. I say, bro, what happened? He said that, you know, I've helped a client to buy a row of shophouses. Okay? I say, that's good news, a row of shophouses. $8 million. He brought the client to see, to view. The vendor was represented by a vendor's agent. Okay, so they met up on the first floor. So the conversation went on. The buyer was quite interested, in fact, was very interested. The price was $8 million for a row. Okay? So then my friend actually asked the vendor's agent, is there a problem to buy? Any problem with these properties? The vendor's agent said, no problem. Look at it. First floor, all restaurants, right? Then my friend asked, second floor, all restaurant also. Should be all zone commercial. No problem. I think they are being used by like the restaurants or the workers to sleep in. So, but don't worry, I think it's all zone commercial. No problem in buying these properties. Although they talk along this line, none of them really know what they're talking about. So they mention about commercial, they talk about restaurant, they talk about this. I think they have some idea, but not really knowing what they're talking about. So my friend said, oh, okay, so it's commercial, restaurant, upstairs restaurants. Nobody bothered to go up to the second floor. So they talk downstairs. At the end, the buyer said, okay, it's a good deal, issue 1%. Right, deposit to the vendor's agent in the name of the vendor. Okay? And at that point in time, they got the option. But the buyer did not take the option to see the lawyer. For whatever reason, I'm not too sure. 4 days later, they met up again. Okay, this time the vendor's agent said, I need you to exercise the option quickly because the vendor needs the money to buy a factory in Tuas. So I need you to issue the 4% directly to the vendor, not to the lawyer as stakeholders, which is the usual practice. And my friend actually gone through the real estate agent course, say that's not very usual, right? The 4%, if I recall, normally should be issued to the vendor's lawyer as stakeholders. Why should I issue it or get my client to issue it to the vendor directly? The vendor's agent say $8 million is a good price, you know. So can you just help the vendor get the buyer to issue the 4%? The buyer agreed. Issue 4%. So a total of 5% of $8 million, which is $400,000, issued to the vendor directly and exercise the option. 1 week plus later, he went to see his lawyer, and the lawyer then called my friend. He said that, by the way, thanks for giving me the work. Have you obtained LDAU approval? That was the first time my friend heard of LDAU. We say, what's LDAU? So the lawyer actually explained LDAU. He said, no, but I think we can apply, right? I said, yeah, sure. Do you know that, by the way, your client, the buyer, is a PR? They say, no, he's Chinese. We say, yeah, but Chinese means what? Chinese is a PR, what? They say, yeah, but I thought he's a Singaporean. They say, no, we check, it's a blue IC, PR IC, so he's a PR, no? PR is considered foreigner under the Residential Properties Act. I say, okay, but foreigners, PR cannot buy shop houses, man. They say, do you check the zoning? They say, no, what zoning? They say, so you have not checked. So the lawyer actually explained how he can check the zoning of the property, so on and so forth. That was the first time in his life he has heard this. So the lawyer assured him, no problem, just go and apply. Okay, not to panic. Okay, so my friend did. Call the buyer, assure him. The buyer asked him anything wrong. He said, no, don't worry, we just need to apply LDAU. And the buyer told him, I know. I've already applied once, and I got an LDAU approval for my bungalow. So this is an investment property, I will not get it. The buyer actually know more than my friend, who's the real estate agent. That's the reason why you're here. You know, you should know more than the consumer, not the other way around. So then my friend said, oh, in that case, if you're not going to get the LDA approval, then how? So he actually asked the buyer how. The buyer said, then can you call the vendor and get my money back? I said, okay, that's a good idea. I think I'll do that. So he actually called up the vendor's agent. By the way, do you know the commercial thing, this and that? The vendor's agent also had some inkling now. He said, oh, commercial, yeah, I remember I told you, right, restaurant. You mean cannot buy? I said cannot. My friend said cannot. Can you get back the 400,000 for me? 5 minutes later, the vendor's agent called, say no. The vendor actually said, money come into my pocket, I will not take out. In exact words. So my friend said, so the vendor is not going to take out. I say, no, 400,000, nothing. So my friend called the buyer. I say, the vendor is not going to take out any money and refund you. Then the buyer told him, then you take out. Simple, right? If the vendor is not going to refund, then the agent refund 400,000. So that's it to my friend. I think he thought that his life has ended. His career is over. So that's when he called me. So we went forward, we went to fight it out, and we won. We were very lucky because at the viewing, right, my friend actually brought a colleague, a junior, beginner's real estate agent. She overheard the vendor's agent said, don't worry, it's all commercial. Downstairs restaurant, upstairs also possibly restaurants, no problem with your client buying at all. Although we are not sure whether the vendor's agent actually know what she's talking about. So because of this little crucial evidence, she testified in court. And the vendor's agent, okay, something like a drama like watch on TV, say, yeah, I say, so what? No big deal, right? The vendor's agent actually said, is that a big deal? I said, okay, we rest our case. She admitted to saying that, but she still didn't see it. Why is that a big deal? Because she didn't understand what misrep was. So we won, and we got back the money. And that case took 1 over a year. So my friend couldn't function properly for 1 over a year, with 400,000 hanging over his head. So this is just an example. So ladies and gentlemen, before you market the property, or before you help your prospective buyer to go and source for a property, know who you're dealing with. Know whether your client is a Singaporean, PR, so on and so forth. And know what properties you're dealing with. And all these informations are readily available out there. Because if you fail to check, you may get into trouble, okay? Some other common examples. Rental yield. Ensure you're up to date with the latest and most reliable rental yield. This is common in tenancy situation. If you're marketing for shopping malls, or owners who own shopping malls, talking to prospective tenants, you may say something like this. Again, I've come across real cases. They say, oh, this mall, you have good human traffic, no problem. Your yield will be 5%, 10%. No idea where these figures, basically came from. It's just your gut feel, because you feel that this is a good area, and you basically market it as such. And when they come in, the tenants, no human traffic, ceiling collapse, all sort of problem happen. And then who they will blame? They will come and find you. All right? Ability to sublet. Okay, there's some typo. Vendor is actually landlord. An example would be a situation where the landlord hasn't given permission to sublet, but you omit to notify basically the tenant and actively promote the property to the contrary. If your property is mortgaged, or if your client's property is mortgaged to a bank, legally speaking, you require the bank's permission before you actually lease your property or help your client to lease. But I know in practice, no house owner or property owner will actually call the mortgagee and say, by the way, I'm going to lease out. Can I get your permission? Nobody, I also don't do that, to be honest, right? We will just call the agent and say, hey, help me to tenant it out. But honestly, if you default on your mortgage payment to the bank's position is not to recognize the tenancy that you have entered into. That is the bank's position, understandably so, right? They will not want to recognize the tenancy agreements in the event that you default on your mortgage payment. So having said that, you may come across tenants nowadays becoming a bit more savvy, a bit more demanding. They will say, okay, now I'm going to rent this property from your client, the landlord. Can I see the mortgagee's permission? And if you can't produce that, then you have a problem, right? Or worse still, if you say, yeah, no problem, I think basically the landlord has obtained the necessary permission to let out to you. You can safely set up shop here and rent this property. And it turned out that that is not true. The property got repossessed, and you're in for trouble. I'd like to share with you, it happened to me, it's something embarrassing, but I'd like to share with you. When I set up my law firm many years ago, during 2003 SARS period, I left a big firm and set up my own law firm, right? I read the papers, I was looking for an office. I saw one at People's Park Center. Okay, at Cross Street. If you drive there, you will see with the billboard SIA. That's the only corner unit with a balcony. Can you imagine office with a balcony? Perfect. You can hold cocktail party and all this. That was my first office. I called the agent, I went there. It was 1,600 square feet. I called the agent and she said, yeah, come down and have a viewing. I went down, it was an elderly gentleman, very polite, very nice. He said that, sir, can I know what business? I said, law firm. They said, young man, law firm, well done. The landlord like entrepreneurs like you. I said, okay, that's very encouraging. That's a good start. I said, what's the price? He said, young man, for you, $1 per square foot. So $1,600 per square foot per month. I said, that is quite cheap, even though it was during SARS period. I said, yes, that's only because you are an entrepreneur. The landlord likes entrepreneur like you. I say, really? I mean, like, what better luck, right? I say that, that's it. I'm in for the money. So I say, you sure? You confirm the landlord? He called, he said, yes, for you, 1,600. There's a long line waiting, you know. If you're not going to take it, it's over, you know. I say, okay, first and foremost, is it haunted? He said, no, not haunted. I said, it's really cheap. I say, okay, thanks for the support, but any problem with this unit? I say, no problem. Why do you think there will be problem? No problem. This is a good unit, right? I say, yes, it's a fantastic unit. You sure the landlord can rent out the unit to me? He said, yes. He's a nice man. When I told him that you are a lawyer, he was so happy. You know, he likes lawyer, likes entrepreneur, you know. I say, okay, in that case, I want 2 years. So issue check 2 years, security deposit, 1 month advance rent, right? 3 months issued to the agent. The agent say, because it's such a good price, can you pay my commission as well? That was my first brush with real estate agent, by the way. Okay, so learn it the hard way also. That's why I'm here, right? Quite ironic. So I say, sure, no problem. Because it's that cheap, I'm going to pay your commission. So 4 months. 2 months security, 1 month's commission, and basically 1 month advance rent. The agent told me, by the way, I need your help. The landlord's wife is, she's suffering from breast cancer. So she's going through cancer treatment. He asked whether you can advance another month of rent. I say, it's not a problem. You know, honestly, how many months? 5 months, right? Okay, 5 months. I issue 5 months to the agent. So that was in May. I had a cocktail party, spent 50,000, renovated the office. And August, one morning I came to work. My secretary said, hey, Patrick, I think there's a letter for you. I said, what letter? Pass it to me. Sat down, read notice of eviction. I said, which file is this? Which client? He said, I think it's addressed to you. No? I said, addressed to me? What do you mean? He said, yeah, it's addressed to Patrick Tan, right? You, right? Can you wake up? You know? I was like, okay, yeah, I think it's addressed to me. Basically, they say that the landlord has defaulted on mortgage for 9 months. And being the mortgagee, they're exercising their right to repossess. Okay, and they are not giving recognition to the 2-year tenancy that I've entered. So that day, my work collapsed. You know, I was stunned. I didn't know what to do. At the end, my secretary said, why don't you just call the other side lawyer, you know? Right? So I called, they say, well, you're the lawyer. Oh, so embarrassing. It wasn't, I didn't know the tenant is a law firm, you know, but you know, my hands are tied, you know, we have to do what the bank says, so we just send you the letter. Anyway, the landlord didn't tell you, man. The agent didn't tell you that actually they're not allowed to sublet or to lease to you. In fact, we have not given them permission to lease out to you. 2 weeks before he leased out to you, we have a meeting. And they said, the landlord said he had no way to pay back. So we told him that we're going to repossess. And he actually leased out to you. I said, yeah. When I asked the agent, he said, no problem. He said, well, that's a big problem now. So I said, how? He said that, I'll see what I can do. So when I called the landlord, he stayed somewhere at Bishan. I managed to get him after the whole day of trying. He said, who is this? I said, this is your tenant. Then I said, okay. I said, I have received the lawyer's letter. He said, so fast, you received? I said, yes, I have received. Then I said, how could you do this to me? He said, well, you know, no choice. Then he said, so how now? You say, you're the lawyer. What do you think? You tell me. And then he put down the phone, right? So that's that. That's finished. Then subsequently, the bank's lawyer called and basically managed to resolve this by allowing me to stay month on month. So they refused to recognize the 2-year tenancy, right? But they allow me to stay month on month, double rent. 1,006 becomes 3,002. So no choice, right? Stay on. So I stayed. So I thought everything is okay, over, no problem. October came. I received a call at 6 p.m. I still remember night friend called. I say, yes. He said, is this Patrick? I say, yeah. Are you the tenant? I say, yeah. I say, good news. I say, wow, what's the good news? I say, do you have 100,000? I say, no. I say, okay, if you have, this office will be yours. I'm selling it to you first. I say, well, what? Wait a minute. I'm not sure what you're talking about. He say, we are putting your property up for auction. Turn up at M Hotel tomorrow, 9 a.m. I say, huh? What do you mean? They say the bank has decided to put your office up for auction. So if you have the money, come down tomorrow. We'll take the property off the listing. You can buy it first. Don't say we don't help you. So again, my work collapsed a second time. So imagine I received the call at 7 p.m. and next morning I actually went to the auction. That was the worst feeling you could encounter, to see people bidding for your office. And there's really nothing you can do about it. So the property was finally sold for 320,000. It was really cheap. And the new owner came, they said, I understand you're the tenant. No problem, we buy for investment, we let you stay. Triple rent. It's all true. At the end, so sad already, I moved out. So after I moved out, of course, the next natural thing is to find the landlord and to find the agent to sue. So when I took out the tenancy agreement, I checked, it was actually entered with a ABC Private Limited. And I said, who is this ABC Private Limited? My secretary said, it's your landlord. So you sign the TA, you got check. So I always advise client to check, right? I myself was engrossed with the $1 per square foot, that I didn't check, and I signed. And then when I did a check, it was a $2 company. So there's really nothing for me to sue. It was a $2 company. So of course, the next logical step will be to sue the agent, right? But my friends managed to persuade me to forget it and move on with my life. But if I were to pursue, then this is something that I will go under for misrepresentation. Okay, because as far as I'm concerned, but of course whether I win or not is a different story, right? The agent had misrepresented to me that the unit could be leased out to me. Okay, when in fact the bank has made it very clear that they are not supposed to do so. Okay, this is just one personal example. Very sad, actually. Implications of misrep and how to avoid. So basically, you must be clear of the facts. Do not represent facts that you are not sure of. Nowadays, consumers are quite savvy. They will ask you, okay, for all those things that you have said earlier about Jurong Lake District or Holland Village, can you send it to me by text or email? So that is all on record. So if subsequently there's anything on misrep, right, they can actually use that against you. So be very careful, okay? Size and tenure of property, you can use in-list check. Brief property ownership information search only costs you $5.25. And detailed property title search actually costs you only $16. So it's actually very affordable, okay? Eligibility to buy, URA website, rental yield, market research, but be very careful. Always put a disclaimer there, all right? And ability to sublet, theoretically, you have to obtain the mortgagee's permission, all right? But I know in practice that's a bit difficult. Now, the difference between offer to purchase and option to purchase. Offer to purchase is not the same as option, okay? So be very careful. Offer to purchase has become increasingly common nowadays. Offer to purchase is normally coming from the buyer, and option is granted by the vendor, okay? Why people would come out with offer and not go direct to option, I'm sure you know the example. Because from the buyer perspective, they issue the 1% check, but then the option doesn't come. So to the buyer, they would straight away want to issue an offer. If accepted, at least they can expect the option to come, all right? So exchange of option and option fee is the first contract form. So I know for a lot of agents, right, when you collect 1% or when you issue the option on behalf of the seller, be very careful. The very act of giving the option on behalf of the vendor to the buyer's agent or if you're the buyer's agent, the very act of giving the 1% check to the seller's agent, you're helping the vendor and the buyer to enter into the first contract. That very act of exchanging the option and 1% check is the first contract. Whether the agent bank in the 1%, it doesn't really matter. Okay? So the act of giving the 1% and taking the option, first contract. And what is the most important term of this first contract? Within 14 days, nobody can, or at least for the seller, right, he cannot reissue again to another person. And from the buyer's perspective, he has 14 days period to consider whether to exercise. If he doesn't exercise, he loses his 1%. All right? So, of course, the option must be signed. Check the option terms before exchange. I've come across cases where the buyer's agent, after giving the 1%, take the option, on the way to see the buyer, reach the buyer's house, realize that the unit number wrong, price different, option not signed, and then they don't know how to show it to the buyer. So moral of the story is that before you give your 1% and take the option, please check. Or ask for a draft option to be forwarded to you before you actually release your 1%. Check first. Make sure everything, all the salient terms are there before you actually release your 1%. Because otherwise, it may be difficult for you to have to countersign on the option. All right? Payment of commission, something straightforward, but actually may present problem as well. Normally, there's a commission clause in the OTP, but strictly speaking, that commission clause is not legally binding between you and the vendor. Because the OTP is strictly speaking a contract between vendor and buyer, not with you. But for some reason that I'm not sure, I always find the commission clause in the OTP. So now you know CEA has a form, so make sure that the form is set to make sure that your commission is secure. All right? And also another point on commission, in practice, right, law firms should receive your invoice in good time before completion. I have received invoices from agents, right, months after completion. Okay, months after we have disbursed all the funds. I'm not sure why. So send it in early to the law firm so that they can actually take into account. Okay? Salesperson are reminded that they are not allowed to dual represent. Okay? They are not allowed to collect commission from both the vendor, buyer, and or tenant and landlord in the same transaction, regardless of consent. Take note, okay? Strict compliance to the estate agent's regulations. Delay failure to complete. So normally once the buyer exercises the option, right, you would think that your commission is secured. Most of the time, yes, but if the transaction is not completed, then there will be a problem. Usually completion schedule for 3 months, sometimes can be shorter, 8 weeks, 4 weeks. It all depends on some of the common factors, whether there's a loan, there's a CPF, and how fast the lawyer work, right? Correct? These are some of the factors. But generally speaking, 12 weeks. What if the buyer or seller cannot complete? One of the common reasons is because the buyer cannot get a loan. But sometimes it can be due to real estate agent's fault. I've come across an example, the estate agent basically misrepresented. Okay, the property comes with tenancy, but basically he prepared the OTP to sell it vacant possession. So he called me, I say, why do you do that? He say, because I can make it vacant. I say, what do you mean? He say, yeah, the owner, you just gotten the tenant in, right? He say, yeah, but I also can get the tenant out. I say, oh, do you do that? He say, no, I didn't manage to do that. That's why I got into problem, you see. I say, okay, that's a bit of a cowboy, right? He say, yeah, so basically, he was supposed to sell with vacant possession, but there was a tenant there, right? So at the end, and the tenant refused to move out. The tenant also know their rights, you see. They say, I'm here already, how can you chase me out? He say, no, under Singapore law, you should go out, you should leave. So he tried to smoke the tenant. The tenant, unfortunately, they will not smoke. So they refused. At the end, the whole team, whole agency went now to beg the tenant to move. So at the end, the matter was resolved, I think 2 weeks before completion. So the deal was that actually this agent paid for 2 years tenancy free for the tenant at the adjacent penthouse. From a 3-bedder to move them up to a penthouse, pay for moving costs, 2-year rental, everything covered. Then the tenants agreed to move. So this was a hard lesson learned by the agent. All right? So if the matter is not completed, right, that means basically failure to complete, then what we are looking at is that lawyers normally would advise the client the vendor to issue a 21 days notice to complete. Nowadays, interest is charged at 8% per annum. Used to be 10, now it's 8%. Okay, and give them 21 days. If within 21 days the buyer still cannot complete, then the deal is off, right? Then you sue. Alternatively, the seller can choose to rescind the contract on the day of completion. That means the buyer cannot complete, then the deal is off. Straight away, the vendor can decide whether to sue. As to which course of action to take, I'm sure you know it all depends on market forces, whether to give more time or whether to call it off. So if your owner happen to call you, first approach is please talk to your lawyer. If the buyer or if the seller insists on talking to you and say which option should I take, then really it all depends on market commercial factors, right? If the market tanks, prices drop, then maybe you want to give a bit more time to the other side to complete. If the market from 1 million become 2 million, then you may want to thank the buyer. You say thanks for not buying, because now I can resell for another $1 million, right? So it's all commercial decision. Okay, bring disrepute to the real estate profession. What is the CEA? It's basically CEA is a stat board established under the Estate Agents Act to administer and enhance regulatory framework for your industry. The principal functions are to license salesperson like yourself and to register salesperson, promote integrity and competence of estate agents and salesperson, and to engage in public education. All right. Disciplinary proceedings, something close to my heart because I'm doing one now. It's a very hard fight. What are these? Basically, salespersons who are guilty of misconduct or breach of code of ethics can be hauled up, okay, may be subject to disciplinary proceedings. And the disciplinary committee, normally 3 people. First, the president will be legally trained, will be a lawyer, supported by 2 from your profession or academia. May, upon hearing of the action, do any of the following: revoke, suspend, impose a penalty not exceeding 75K, reprimand you, or attach conditions to your practice. All right? Case study, bring disrepute to the profession. CEA charged a former real estate agent for representing both landlords and tenants in the same property transactions, handling money for the landlords and tenants, and for not attending before a CEA inspector. Basically, the agent facilitated the lessee of a 2-room HDB rental to enter into 3 separate subtenancy to rent her 2 flats to the 3 different subtenants. So she advised both parties regarding the lease and received commission from both parties. Dual representations. All right? Now, last but not least, quickly, we have to cover these various methods of dispute resolution. It is one thing to know about all these potential common problems. Knowing is one thing, but let's say if you get into one, unfortunately, you have to know how to get yourself out, all right? And some of these common methods, okay, even if the other side were to commence legal action or has commenced legal action, it doesn't mean that you have to similarly also engage lawyer to fight back. You may attempt negotiation, or for yourself, for your industry, you have mediation and arbitration, okay, to consider before going to court, and what to expect and how to prepare for each method. Negotiation is the least formal of the processes, basically involve a dialogue between 2 parties, and ultimately, if the matter can be resolved amicably through negotiation, there will be a settlement agreement reached. All right? It's a settlement contract signed by both parties, normally between the seller and the buyer, or the landlord and the tenant, something that you help to facilitate. This does not involve court, and most of the time does not involve lawyers. Okay, so it's a relatively cheaper and fast-free option. Mediation is an alternative method of resolving disputes. It is a process which a mediator like myself help parties to negotiate. So there's a certain system or process in place to help parties mediate. So normally each one will have a goal, present their case, and then the mediator will try to identify certain issues and hopefully can come up with alternative solutions. Again, if there is a settlement, then there will be a contract drafted, signed by both parties. And the good thing about mediation is that it is confidential. Okay, and whatever you said during mediation cannot be used outside the mediation room. So that outside parties and all these people will not come to know. So it is a fairly affordable, quick, and efficient process to resolve dispute. Arbitration, a private matter or dispute resolution used when parties agree to refer their dispute to arbitration. Parties normally agree to arbitration by means of arbitration clause. So if you go for arbitration, normally you are going there to fight your case. It's what we call a private court. You get to appoint your arbitrator, like a private judge. So the good thing about this is that you get to pick and choose who to hear your case. In the court of law, you can't pick the favorite judge or something like this to hear your case. All right? In arbitration, you can. So in arbitration, you get the judge or the arbitrator to rule who is right, who is wrong. There will be a judgment, what we call arbitral award. In mediation, you do not get an award. You do not get a judgment. What you get is a settlement agreement. So in mediation, nobody talks about winning or losing. It's a compromise. Whereas in arbitration, we have an arbitral award. All right? And the award is as good or as enforceable as a court judgment. All right? Some of the advantages of arbitration is private. SIAC, Singapore Institute Arbitration Center. Parties can select their own arbitration rules. Cost, finality in the award, and ease of enforcement, it's just like a court judgment. But there are some disadvantages. The arbitrator's fee can be exorbitant. The whole process may not be as quick going forward, and there are limited avenues for appeal. For yourself, your industry, CA actually has a dispute resolution scheme. For the resolution of relevant disputes, which arises from relevant estate agency agreement entered between a client and a licensed estate agent from 2011 January onwards. So participation is basically compulsory for those in the industry. There are two sub-schemes, mediation and arbitration. So you guys will go for mediation first. If it fails, straight away the process will become an arbitration. All right? And of course, last but not least, going to court. Even if you go to court, if your claim is below 10,000, please consider small claim tribunal. Okay? If your claim amount is less than 10K, you can actually go small claim. If it's above 10 but below 20, with both parties' consent, you can still go small claim. Small claim cannot involve lawyers. It's a DIY process. So it's fairly quick, fairly fast, and also the small claim court order is as good as any court order. Last but not least, if let's say you do not want small claim, get a lawyer, call me, we will go to court. Normally, we'll issue a letter of demand. 7 days, no news, we will issue summons. Depending on the claim amount, we're looking at magistrate court, district court, or high court level. All right? Thank you. That's the end.